There's only three things that you need in the state of Florida to have a valid last will and testament. If you pull the law, also known as Florida statutes, and you look at Florida statute section 732.502, that governs the execution of wills for last wills and testament in the state of Florida. Now remember, a last will and testament deals with what happens to your property and all your stuff when you pass away. Who gets what? That's what a last will and testament deals with. There are only three things in the state of Florida that a valid last will and testament must have. The testator, the person who is drafting the will, who is writing on the piece of paper the will, must sign at the end of the document. The testator, the person who created the will, must sign in the presence of two witnesses. So if I'm making a will, I sign the will, there's two people watching me sign the will, and then they sign as witnesses to the will, and we all sign together. They see me sign, and I see both of them sign. And importantly, it says here, under Florida Statute 732.502, subsection 4, no particular form of words is necessary to the validity of a will if it is executed with the formalities required by law. So what that means to me is, as long as I've signed at the document, signed at the end of the document, in the presence of two witnesses, those witnesses saw me sign and I saw them sign, then we have a valid last will and testament in the state of Florida. Now you could go above and beyond. In future videos we'll talk about self-proving wills. We'll talk about revocable trusts and living wills and powers of attorney. But for a last will and testament, which governs what happens to your stuff when you pass away, if you want to ensure that your children or your surviving spouse receives your stuff, and you want to make sure they receive your stuff, then you need a last will and testament. And you only need three things to have a valid will in the state of Florida. You need to have, one, a signed writing, meaning that you wrote on a piece of paper what you want your will to be. It does not need to be anything special. It could literally say, this is my will, I want my wife to have everything. Then, at the bottom, you need to sign. And importantly, the third thing, you need to sign in the presence of two witnesses. And those two witnesses need to watch you sign, and importantly, they need to sign. So a last will and testament, from a very high level, basic last will and testament, has three things. It is a signed writing with two witnesses, and everybody sees each other sign, and everybody signs together at the bottom of the document. And that's all you need. And if you want to confirm, you're more than welcome to pull Florida Statute 732.502, and you could read for yourself. The testator must sign the will at the end. The testator must sign in the presence of at least two attesting witnesses. The attesting witnesses must sign the will in the presence of the testator and in the presence of each other. You all have to sign together. All have to sign at the bottom of the will. The will must be in writing. You cannot have a verbal will in the state of Pennsylvania. You cannot have a will in the state of Florida. You cannot have a will in the state of Florida that you just signed. I can't just make a piece of paper right now that says, George will to wife, and I sign it. Not valid in the state of Florida. You need to have a signed writing by the person making the will in the presence of two witnesses. That's it. You don't need anything more. You don't need anything special. You don't need an attorney. You probably should have an attorney, because we can make a much more formal will. We can ensure those formalities are properly done at the time, and we could also self-prove the will to make it easier on your loved ones later should you have to go through probate.